headquarters into the whole idea of vetting? Should consensual dispute resolution attorneys, should they be saying like, no, 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 sorry, you can't do collaborative practice. You've got to do something over here, right? And that's a discussion that's worthy of a whole day of sitting and training, much less. So I'm just going to mention that as an aside. So collaborative practice, the two elements are the withdrawal clause, right? And that it is a non-adversarial process, which means that all information can come into a collaborative practice process. Right here we have discovery, right? Discovery is saying, okay, you can get this, I'm going to withhold this, I'm going to give this, right? I'm going to make you give me that. Right? You know how crazy making that is for people getting divorced when they get forced, right? Has a tendency to make some people say, wow, now I'm really angry, I'm going to try to force you. Right? So then you get that kind of adversarial dynamic going. In collaborative practice, it's all about 100% transparency and all consensual dispute resolution. 100% transparency. If someone wants information, they get it. Right? Lawyers don't sit and quote evidence or discovery or any of those notions. And if one client says, I'm not comfortable, I don't feel safe, I don't want that coming in, right? Then what you do is you remind them of the second element in that stipulation and order that they signed with you, or the contract they signed with you. One, withdrawal clause, right? You're not part of the process if they don't come to an agreement. And two, the process is 100% confidential. Now, I don't know if you guys have been exposed or not, but in California, there's actually an evidence code making mediation a confidential process as long as you use all the right buzzwords in your agreement. Right? So there are laws in place that make a mediation confidential. As of right now, there are no laws in place that makes a collaborative practice process confidential. So you have to contract for that. Right? So if you're going to practice as a collaborative practice attorney, right, two of just the basic elements are you withdraw if they don't agree, and you're operating in a totally confidential process. And then we have facilitative mediation, which I want you to notice and distinguish here between evaluative. One thing that consensual dispute resolution attorneys often find is that many legal professionals identify themselves as practicing this, where from a different view, we might evaluate them and say that they're practicing this. Evaluative mediation is you're projecting your own life experiences onto the people you're working with. You're projecting your legal notions and background onto the people that you're working with. Facilitative mediation and collaborative practice, if practiced ideally, right, you are actually, and your views and your thoughts do not affect the process at all, and do not affect the decisions that the clients make. Right? In consensual dispute resolution, as a legal attorney, as an attorney, you basically have two jobs. Right? So now I've kind of gone back up here to the macro. So we were talking about collaborative practice. We were talking about the two things that all of us attorneys here in the room need to understand, that there's a withdrawal clause, and that it's a confidential process. All these other elements that I've written on the board, you can go to Australia and talk to collaborative practice attorneys, and their form of collaborative practice is going to look real different than it does in Minnesota, where it started. It's going to look real different than it's practiced in England, right? So those are the two defining characteristics of what makes collaborative attorneys sit down with each other and say, we do the same thing. That said, different regions, different policy. Some regions say, you know what, you have to use other professionals. Wow. So that's a real big difference. Here, the attorney has a tendency to use other professionals as experts, as sources of information. Here, the relationship that an attorney has with a potential financial specialist, a child specialist, there's also a professional that's mostly called a coach. In my office now, I've adopted a term that's used in Texas quite a bit for a family relations specialist. I found when I said, hey, you want to work with a divorce coach? This is what they do. People would be like, whoa, no way, that's like a life coach. Yucky. Hello, I'm in a mediator attorney's office. This is all business. But then when I started saying, well, you've got some interdisciplinary choices here. How'd you like to engage a financial specialist? They're like, that sounds really smart, right? Because what have I done? I've diminished to them the value that I can be prior to asking that question, because I've told them, heck, what do I know? I've witnessed a lot of divorces, yes. And I know the law around family law pretty well. But you're in an environment where you're not allowed to use the law to try to force someone to do something. If y'all want to do that, you got to go over here. That's not what I do, right? So then they're like, well, wait a minute, then wait, why are we here? Well, we forgot. And I say, okay, here's the deal. One is, there is a role of the law in consensual dispute resolution, right? One role is it can be one example, one option out of tons and tons of options, right? So we might say, okay, husband has come up with 7 ideas of how they can deal with the underwater house. The financial specialist has come up with 3, right? And the other person, right, wife, has come up with 4 of her own. So we're gonna look, and we're gonna say, okay, here are the options. And then sometimes the clients go, well, wait a minute. We want to know what would happen to us if we were over here. Because maybe we'd like that as a result. We don't know. Hey, Unmani, can you tell us the law around what would happen with our underwater house? Right? That gives me the opportunity to say, okay, as we all talked about at the beginning of the process, I provide neutral legal information. Keyword, information. I do not provide legal advice. There's a distinction in the dicta of a California Supreme Court case, right, that makes that distinction. So is it binding? Does it make consensual dispute resolution attorneys kind of nervous, right? I have in my fee agreement, I don't give legal advice, then a whole paragraph, and then I have the opposite. I give legal information, and a whole paragraph on what that is. And I make it clear, the law can come in here to the extent that you both agree that it's helpful as a resource for options, right? I have people all the time that want to use a child support calculator. Why? There's good reasons for it, and that's a talk for another day, right? But they say, oh, that piece of the law, that works well for us, right? There are other people that say, don't talk to us about the law at all. So our job is to give them neutral legal information so that A, they can use it as an option, or B, let's say the 2 folks don't agree, right? Every consensual dispute resolution attorney's bummer moment when you reach what's called in the community impasse, right? You, your team members, right? Everybody involved has tried their best to support them, to educate them, right? To create a safe container where they can make decisions from their mind and not from their emotions, right? Which, hello, people getting divorced, that's such a hard row for all of my clients ever to make. And it's because for most of my clients, I can't say all, I have the folks who have been separated for 5 years, they're best friends, they go out and have coffee before they meet me. Yeah, those are nice. But really rare. Most of the time they come in my office and they scream at each other, you know, which gets like, whoa, whoa, time out, all right. Whoo, boy, we're feeling really upset today. What can we do to create a safe container here? So that both of you realize I'm not going to run back to my office and create a marital settlement agreement based on what we've talked about and force you to sign it. You're not going to get forced to do anything here. Can we take it down a notch? Or do we need to end for today? Right, those are just, again, concepts of how we behave as attorneys in a consensual dispute resolution process. We give them neutral legal information because it's one of a myriad of resources for options. And we also let them assess, okay, we've reached impasse in here, right, bummer. What would happen to me if I came over here? Because let me tell you how many times I have someone say, that's not acceptable to me. I'm not agreeing to that. There's no way whatsoever. And then they ask me, can you give us some neutral legal information on it? And when I do, sometimes they get so angry that they stand up and storm out when I tell them about spousal support law in California. And occasionally I distinguish it with spousal support law in Texas and spousal support law in Oregon. Because when you do that, what you've done is you've diminished the idea that the law is some sort of obviously just, obviously right way to do it. Hey, get this, so maybe they're just all jerks in Texas. That could be it. Or let's just look at the way they look at it. You know, maybe up in Oregon, you know, I've never really been there much, but maybe they're just a bunch of yahoos because they even do it differently than that. So when I give people neutral legal information on California law, again, sometimes it can be helpful to bring in law of other areas to diffuse its power. And when people sometimes hear around the law around spousal support, how amorphous it is, I mean, a 16-point test, right? Go into one courtroom in the same county, in the same building, present your information, and you can get amount A and truck right down the street maybe down the hall with all the same information, you get a totally different result. That just makes clients' minds blow. Because they think legal information is actually going to give them the answer. What you're doing a lot of times is demystifying that any of these people has the answer. Or much less, God bless, that you have the answer. Right? We tell them, I don't have the answer. I'm not an expert on your life. I don't know what's best for you. I don't know what kind of bets you want to make. Right? And so when impasse happens, we give them neutral legal information, because then occasionally they have to do what I tell clients is called swallow the bitter pill. I don't promise my clients that they're going to love their agreement. I don't promise that they're going to go, oh yeah, let me sign that. This is great. Oh, Unmani, thank you so much. Most of the time, not most, but every once in a while, I have people be like, I hate this. I feel forced, and all of that. But what they're doing is they're making an educated decision, because they know if they leave here and they go over here, the result could be much, much worse. So that said, do any of you have any questions about the concepts that are here on the board differentiating these two processes in the sense of mechanics, right? Collaborative practice, always two attorneys, different regions, different models, and you have notions of an interdisciplinary team, like in San Diego, you have to take the entire team, period. As in 2 attorneys, 2 coaches, child specialists if there's minor children, and a financial specialist. And if you don't like it, you can't do collaborative practice in San Diego. Though, now in 2011, I haven't checked in with any of my colleagues down there. I wonder if it's not like that anymore. Because of the economy. But anyway, last time I checked, they were still doing that, and they were very gung-ho. Facilitated, and for good reason. The interdisciplinary team, that's again a whole nother talk. Fantastic, right? Because the law makes people usually feel pretty scared or really psyched, which then that's not the greatest dynamic either, right? But the interdisciplinary team, they are your friends. They honestly can make or break so many processes that my clients really have often a debt of gratitude to the interdisciplinary professionals that support them. And then facilitated mediation, right? 1 neutral, consulting attorneys. Lots of attorney mediators require that people have consulting attorneys. Why? And I'm guessing that it diminishes their liability, right? Like, whoa, hello, attorney signed that. I am just a neutral. I don't require it personally. Occasionally that can make me nervous. But a lot of people that choose to work with me kind of say, we're here because we don't trust this process. We're here because we're afraid that anyone who's related to this process will infect us. No, I'm serious. It sounds really dramatic, but I literally had people use the word infect. Like, this is toxic, and this is poisonous. Anyone who got divorced and got dragged through the coals? And it ruined their life or changed their life forever, made them bitter, or what have you, or destroyed them financially. Maybe you guys know somebody who's like that. Well, just about everyone who walks in my office does. And they're like, we want a legal quality agreement. We want sophisticated knowledge. We want to understand tax treatment. We want to be able to have a conversation where we've considered all of the angles, again, from a sophisticated perspective, but we don't want some lawyer with this mindset to infect the fact that even though this is going to be difficult, even though we're actually differentiating, or like in probate, in consensual dispute resolution, those are people fighting over, they've got grief from the death of a loved one on top of the fact that they're fighting with people that they're related to, either by blood or not, right? So people who have that going on in their lives, a lot of times are almost phobic about bringing in this stuff. Again, not everyone, because the people who embrace the traditional legal, who need a third party to say, here's your agreement, right? Most hopefully they end up there. Again, a system that is very good and meets people's needs. Here, people in lots of ways have to self-evaluate. So now we know what we're talking about. Does anyone have any quick questions before I go into how do you practice this in a sense of opening your own law firm? And how do you practice this in the sense of how many classes in law school even address this concept? In Canada, right? In Canada, people can go into law school. They can declare a track, right? Put me on this track, I want to learn how to do this. Or, put me on this track, I want to learn how to do this. Yeah, like some people say, well, I learned to counsel, so therefore